Good afternoon, everyone. Welcome back to Business Law 1. Today we're going to be looking at Chapter 10, which involves real assent. And we're looking at, in terms of the learning objectives for this chapter, to understand, how contracts require what's called a meeting of the minds between competent parties. So we'll talk about capacity and the ability to contract in this chapter. We'll also talk about how parties, in terms of how they enter into a contracts, it's based on a voluntary process. And there's, no element of duress or undue influence. There's no misrepresentation or fraud that, is a predicate for the creation of the contract. And then how we deal with mistakes and how that could possibly make a contract voidable. So if you remember when we covered the initial chapter involving those kind of required elements of a contract, offer, acceptance, consideration, I talked about different categories or classes of contracts. And one of them was like that voidable and void or valid. And so in this chapter, we're going to kind of revisit in a little more detail that aspect of voidable and void. So when we talk about capacity, that just is the ability to understand that what you're entering into is a contractual obligation. And so whatever, in terms of the terms, are required for that obligation. Is it a single transaction where, you're at a grocery store and I'm actually buying a loaf of bread or a gallon of milk? Or is this, am I purchasing a home where it's like a 20 or 30-year mortgage? Or am I purchasing a vehicle that has, 3 to 6 years, financing, whatever it is? You have to understand the nature of what you're entering into is an obligation as per the terms. Anyway, incapacity can exist in some unique situations, and we'll talk about age, medication, drugs, alcohol, illness, age. So those are some things that we'll talk about. In many of these cases, if someone does kind of suffer from one of these recognized incapacities, it offers the agreement as being voidable on the part of the person who is, I don't want to say suffers, but the person who has that incapacity. Let's go with that. There is one instance that I'll mention, and I'll kind of go into briefly, where the agreement is per se void. It's not an option. It has to be terminated. So when we talk about age, we're talking about minors, so individuals that are under the age of 18. And so minors can avoid most contracts as long as they are not considered a necessary. A necessary usually involves medical care, education loans, insurance policies, some limited cases involving sustenance and shelter. So if it's any one of those types of categories, then a minor wouldn't be able to disavow those contracts. But anything else, a minor would be able to, as long as they do it by the time they reach majority, so as they turn 18. So sometimes I'll give the example of, let's say a teenager buys a PlayStation. Let's say they're 15 years old and maybe they had a part-time job, and so they saved up their money and they go to Walmart, they buy this PlayStation, and they use it for like 2.5 years. So they're 17, not quite 18 yet. Obviously, the return policy normally states that you've got a very limited window to return electronics for any retailer. And so the teenager, though, they actually have until 18 if they decided that they wanted to return it. They obviously have to be able to demonstrate that they're the ones who purchased it and not a parent or other adult. But if they can actually demonstrate that, then they can avoid that contract while it's still being a minor. The only thing that they have to do is they have to return whatever consideration it is that they received. So they'd have to obviously return the actual PlayStation. That's what they're returning. So if the consideration has been damaged in some way, many states do have a provision that will kind of offset whatever kind of refund they're entitled to. But as a matter of principle, they are able to return it. I had a neighbor, this was years ago, and his son, who was 16, purchased a used motorcycle that someone was selling in the neighborhood. And you could imagine the parents not being very thrilled, when their son came home with a motorcycle. But after that initial shock, they realized within a few days that there was something wrong mechanically with the engine, and the motorcycle was essentially just shot. It was not going to be functionable. So, the neighbor was talking with me about what should I do, and I said, well, did you guys pay for it? And he said, no. He said, our son did. And so I said, okay, just go back to the seller and say, my son's 16, and he wants to return the motorcycle. He wants a full refund. And obviously, they did that, and of course the seller was like, they balked. They're like, no, we're not giving you a refund. It was an as-is transaction. And I told my neighbor to tell the seller we'll talk to an attorney, which they did. And of course, soon after that, the refund was made, the bike was returned. But that's a risk you take when you're selling to someone under the age of 18. If you want to avoid that, tell the minor, come back with an adult and have the adult handle the transaction, and we'll sell you whatever you want. But there's a risk that you take if you're selling to a minor something that is not a necessary. They could potentially avoid it because it is a voidable transaction up until they reach 18. If someone is mentally incompetent, then the voidable aspect is very similar to that of a minor. So as long as they still have that mental impairment, then they can disavow, or they can avoid that contract. An important distinction is made here that if someone suffers from a mental impairment and it is severe enough where they actually have a guardian put over them. So a guardianship is a special legal proceeding where you're essentially being stripped of all of your rights to make decisions for yourself, and you're allowing some other person to make those decisions. So that can include where you live, what you are allowed to do, what you're not allowed to do, what you eat, where you sleep, all that stuff. And it's a very serious proceeding if you're seeking to get a guardianship over someone, because essentially they're saying they can no longer take care of themselves or make decisions for themselves. If that is the case, and the person who has a guardianship, over them, if they somehow enter into a contract, those contracts are just per se void. They're not voidable, they're void. Even if everybody is okay with it, the person who has to enter into a contract would be the guardian. That's the person who legally is entitled to enter into that type of contract. When it comes to intoxicated persons, this becomes kind of like an evidentiary issue. If you're trying to back out of an agreement, you have to be able to demonstrate that at the time the contract was made, your sensibilities were impaired because of, it could be alcohol, it could be maybe a new medication you're taking. Sometimes medications have, interactions and adverse effects that could sometimes cloud your judgment. And so again, you have to be able to demonstrate all that if you're trying to justify saying, well, I want to make this agreement avoidable, and I want to back out of it for some reason. I give it's kind of popularized in media, in TV shows and in movies, if someone gets drunk and they get married in Vegas. Obviously, if you're intoxicated to the point where you don't really understand the nature of what you're agreeing to, then you could avoid that. And if it's a marriage situation, what you would really ideally want to do is get an annulment. An annulment acts as if the marriage never occurred. If you wait too long, let's say you end up, you realize you're married and it's like it's been, you for some reason you wait months, then a judge actually could force you to go through the divorce process. The reason why you don't want to go through a divorce process is that then your assets are potentially up for distribution. If it's annulled, there's no asset distribution because the marriage never existed. So anyway, another thing that can come up that is discussed in this chapter involves mistakes. And there's usually two categories of mistakes that can occur. There are what are called unilateral mistakes and bilateral mistakes. A unilateral mistake, by its very label, it's a one-sided mistake. And so if a mistake is unknown to the other party, usually that does not affect the binding character of the agreement. So let's say the party that didn't make the mistake, so if I call you and I'm a salesperson and I say, I'm selling, let's say, business supplies, and I misquote a price and you have no idea that it's been misquoted. Normally we would have to kind of honor that agreement. But if somehow the mistake was known by you, and let's say that, you heard me misquote a price and you're like, well, I'll take 1,000 of those things, whatever it is. Obviously, then I could avoid that because you would be taking advantage of that situation. Again, it's kind of like with the intoxicated person standard. You have to somehow be able to demonstrate, through evidence that, you knew or you should have known, and then that you were trying to take advantage of my mistake. The other type of mistake is a bilateral, and this is where it's on both sides of the contract. And so if both parties are mistaken about a basic material fact of the contract, the party, again, that's adversely affected can avoid the contract. So material facts go to, quantity, price, quality, that kind of thing. Um, but if there's a mutual mistake regarding the judgment or the perception of the value of what's being contracted, normally we're just going to say, even if you were both, if you both had the wrong perception of the value of something, if you were both in agreement about that incorrect perception, then we're going to say that's enough to satisfy that at least you were both on the same page. There was a meeting of the minds, even if it was incorrect. It's not in this textbook, but in a previous textbook, the example was that someone owned a racehorse, and the owner felt that the horse was getting older, and its racing days were over. So the owner sold it, and the buyer also felt that the horse really was not going to be racing anymore. So they both, there was a meeting of the minds there. After a few months, the new owner, the party who purchased the horse, they realized that the horse seemed to be pretty, spunky and lively, and still could run, and so started to enter this horse started to be entered into races and was winning. So the seller found out about this and sued, saying, "Well, I want either my horse back or I want more consideration. I want more money because this is a racehorse." And the response is that, well, we both felt that the racing days were over for this horse, and the fact that I was able to kind of realize after the fact, that's my benefit, and you were not entitled to any of that benefit because at the time of the transaction we did have a meeting of the minds. So deception. So when we talk about fraud, that usually is, some sort of material misrepresentation. So it's a false statement, and it's usually the knowledge, it's made with, there's knowledge of the false or reckless indifference regarding the truth. The intent is that whoever you're telling it to, they're going to rely upon that, and as a result, they're actually going to be harmed because they're going to act on what you told them, which was untrue. So if we're talking about statements of opinion, normally that's not going to be considered fraud. But if we're getting to a factual statement, though, you might say, I really don't know if this is worth, fill in the blank, in terms of the appraised value. I think maybe it's something less. It's like, well, if that's your opinion, okay, I get that. But if you're intentionally, stating that, okay, there are things here that are going to devalue this price, that's different. So statements of opinion normally are acceptable, but if you're presenting it as factual information and it's untrue, or you're extremely reckless with the truth, then that would be the basis for an allegation of fraud. And if you're the victim, so let's say you're the buyer and you've been defrauded, then it's easy. You go to court, you bring in whoever the seller was, you present the evidence, because everything in a courtroom is driven by evidence, and be able to demonstrate, well, these misrepresentations were made about factual things, and because of that, I relied upon it, and to my detriment, I'm now here. And then you're seeking either some sort of additional consideration or damages, or maybe you just want to avoid the contract. So you've got different options there. Deception also occurs in relationships where you have maybe a special relationship with a party. Because normally the general rule is that you have no legal duty to volunteer information to another party. That's that caveat emptor, the buyer beware. And so we have this, the standard that, it's like, well, you can't misrepresent, but, you don't have to, volunteer necessarily information to the other side in many cases, unless you have a special relationship. So if maybe you knew of defects that could not easily be discovered, then that obviously needs to be noted. if the parties are part of a confidential relationship. A great example here, and I get into this more in business law too. I've seen many partnerships where one or more partners are trying to deceive the other partner or partners, and so that obviously is a confidential relationship that requires disclosure and no secreting of profits or secreting of partnership opportunities. The other situation is if the seller takes affirmative steps to actively conceal the defect. And again, that goes to just the deceptiveness of what someone is engaging in order to kind of complete the transaction of whatever it is they're trying to sell. The last part of this chapter talks about pressure, and so as a premise to all contracts, we believe that there's free will, that persons voluntarily enter into contracts, and if you can demonstrate through undue influence or maybe duress, then that would be the basis to kind of have a contract be voidable then, and you'd be able to back out of it even though you've already entered into it. So undue influence would be where the beneficiary of the contract is in a position of extreme power over the maker. Again, it's very factual, specific. Duress usually takes one of two types. There's physical duress, so that's, enter into this contract or you're physically going to be hurt. So, again, if you're in that situation, you may not be, very forthright in saying, I want to go to court and avoid this, because you still have that underlying physical threat. But, it's there. The other type of duress would be economic duress, and that really goes against free will. There was a case involving a person named Richard Case. He owned a bicycle store, and Callahan Manufacturing was a supplier of parts for bicycles, and so Case had an outstanding order that he was waiting on, and he had this exclusive agreement with the manufacturer that he would buy all of his supplies through them for bike repairs. And the annual contract was coming due, and so when he called and said, where are the parts that I've ordered, they said, well, we're in a process of satisfying that order, but before we actually ship it, we'd like for you to sign next year's renewal of the contract. And so what really was happening here was a form of economic duress. The threat is that we're not going to process your order timely until you re-sign your contract, so that we're your exclusive supplier in the future for another year. And so obviously what he did was, sure, I'll sign it, and then after the fact goes to court and then challenges the validity of that, saying, I didn't really want to sign another year, but I needed those parts, and they were kind of holding those parts hostage until I signed this agreement. So he was able to establish that economic duress had occurred in that case. Anyway, I hope that this helps kind of explain, some of the nuances regarding the avoidability of contracts, even though you've already entered into them. If you have questions, as always, please feel free to call, email, text me, whatever is easier, and I'd be more than happy to answer any questions that you might have. So have a good, safe, productive week, and I'll be chatting with each of you online. Thank you so much.